Welcome to EU Privacy for All, Session 66 on GDPR, Opinions of the EDPB, Article 58. In negotiations regarding EDPB opinions, European Parliament suggested notably that the opinion to be released by the EDPB should take into account whether the matter presents elements of novelty, taking account of legal and factual developments, in particular in information technology and in the light of the state of progress in the information society, and also whether EDPB has already issued an opinion on the same matter. Those opinions should be adopted by a simple majority. On its side, EU Council suggested that should be taken into account the complexity of the subject matter to define the period in which the opinion should be adopted and commented. The chair of the EDPB shall inform without undue delay each supervisory authority. Some of those European Parliament and European Council proposals were retained in the final draft of Article 58. In paragraph 1, it is laid down that the EDPB shall issue an opinion whenever a competent supervisory authority intends to adopt one of the measures following. First, a list of processing that would be mandatorily to be framed by a data protection impact assessment. Second, whenever a code of conduct should be adopted. Third, when criteria for accreditation of a body regarding code of conduct or certification shall be established by a DPA. Then determining also when standard data protection clauses would be adopted nationally, or authorizing contractual clauses whenever it is a DPA and not EU Commission authorizing such set of clauses. And finally, approving, nationally once again, binding corporate rules. Any supervisory authority, the chair of the EDPB and the Commission may request that any matter that would produce legal effects in more than one member state shall be examined by the EDPB, in particular where a competent DPA does not comply with the obligations for mutual assistance. Additionally, the board shall issue an opinion on the matter submitted to it, provided that it has not already issued an opinion on the same matter. This shall be done in the frame of an 8 weeks deadline by a simple majority, but this 8 weeks deadline might be extended by a further 6 weeks. If a member of the EDPB has chosen not to object within the reasonable period defined by the chair, it will be deemed as being in agreement with the draft decision. Finally, DPIAs and the Commission shall without undue delay electronically communicate to the EDPB using a standardized format any relevant information. The chair of the EDPB shall also without undue delay use electronic standardized formats to inform the members of the EDPB of any relevant information, as much as the competent and concerned supervisory authority of the decisions taken by the EDPB. No decision shall be adopted by the competent supervisory authority while needed. The supervisory authority that is concerned shall take at most account of the opinion of the EDPB and shall, within 2 weeks after receiving the opinion, electronically communicated by the chair of EDPB, state whether it will maintain or amend its draft decision. Where the DPA decides not to follow the opinion of the board, in whole or in part, the consistency and dispute resolution mechanism set in Article 58A shall apply. This Article 58A, in paragraph 1, lays down that in order to ensure the correct and consistent application of the regulation, the EDPB shall adopt a binding decision where a competent supervisory authority does not request the opinion of the EDPB or does not follow its opinion, In that case, any supervisory authority concerned or the Commission may communicate the matter to the EDPB. Currently, the directive lays down in Article 28 that each DPA is competent, whatever is national law applicable to the processing in question, to exercise on the territory of its own member state the powers it was conferred, in accordance with the directive. The supervisory authorities shall cooperate with one another to the extent necessary for the performance of their duties. What should accountable data controllers and processors get prepared for? First, knowing that the EDPB will be issuing an opinion whenever a competent supervisory authority intends to adopt a list of processing submitted to Data Protection Impact Assessment, Code of Conducts demonstrating compliance with the GDPR, criteria for accreditation of body, dealing with Code of Conduct or certification, standard data protection clauses adopted nationally, contractual clauses authorized nationally by a DPA, or binding corporate rules. Any DPA, the chair of the EDPB or the Commission may request the European Data Protection Board to adopt an opinion, notably when the issue at stake regards mutual assistance. The opinion shall be adopted within 8 weeks by a simple majority, but it is possible to extend by 6 weeks, depending on the complexity of the matters. An EDPB member not objecting within a reasonable period set by the chair of the EDPB will be deemed in agreement with the decision taken by the EDPB. Finally, a data protection authority could in the end decide not to follow the opinion of the board. In such a case, the consistency and dispute resolution mechanism set in Article 58A, and that will be described in next session, will be used. So the questions triggered now is knowing about the predictability of national DPA's decision with regard to the European Data Protection Board opinions.